Stone. In this case, the claimant was injured when a ball flew in from a neighboring cricket pitch and injured the claimant. And the part of her home where it flew into was outside her house. And in the case, it was noted that the cricket field had taken certain precautions when building their field. So the distance from the ground to the fence of the cricket field was about 17 feet. And so the claimant sued, but the courts held that the cricket club or the cricket field was not in breach of their duty of care. This is because the claimant failed to prove that the cricket club owed her any duty of care, and she also failed to prove that the claimant failed to take reasonable action in preventing this breach. The duty of care also occurred when the standard of care falls below that of a reasonable man. And in that, you made a mention of the case of Vaughan versus Manlove and Maguire versus Western Morning News. The standard of care is, you explained what the standard of care is. It is the standard that a reasonable man takes. The peculiarity and knowledge of the defendant are immaterial to the standard of care. The eccentricities of a person don't matter when the standard of care is involved. And the test that is taken in the standard of care is the objective test. Lord Macmillan, in the Glasgow Cup case versus Murray, he explained the test of the reasonable man eliminates the personal equation and is independent of the idiosyncrasies of the person that is involved. A reasonable man is an average. You also explained who a reasonable man is, and you did a very vast explanation of that. You explained that a reasonable man is the average adult person of normal intelligence with knowledge and understanding of everyday events and realities. Under that, there's the English explanation, the American explanation, and then the Nigerian explanation. In different cases, different judges gave different explanations in their societies. So in the English law, it was under the case of Maguire versus Western Morning News. Am I wrong? In that case, it was the average man who is on the Clapham bus. That was the explanation the judge gave in the English law. Under the American law, you have the case of Hall versus Rowling's Auto Racing Club, where a man who picks up the magazines and pushes his lawnmower in a short sleeve, that's who the average man is. Then in the Nigerian setting, Kayode Shaw explained in the case of Adekile versus AG Oyo states that a normal housewife and not the person who drives around in an air-conditioned car, that's a normal housewife and a normal man who goes to the markets to buy his stuff, that's who you consider the reasonable man and not the extra comfortable person. Yes, so you also explained the factors to determine the breach of standard of care. You gave us 4 factors in that regard: the magnitude of the risk, the importance of the object to be attained, the standard and approved practice, and the practicability of the precautions taken. The magnitude of the risk, you gave us the case of Bolton versus Stone, and you basically explained that when you look at the risk, you explained the particular case of Hilda versus Associated Portland Cement, where the claimant lost his eye when he was doing his work in the factory. And then you explained that the risk of his eye being lost and his second eye being lost, the magnitude of the risk is very, very wide compared to something smaller. And so the company had not taken reasonable care to avoid breach of their care, and so the company was held liable for the loss of his eye. Then the practicability of the precautions taken in the case of W&J Latima versus C, you explained that in this case, you weigh whether the cost of the accident you weigh the cost of the accident and the cost of the precautions taken. So in the case, there was a flood in the factory, and then the company had taken all the necessary precautions. They had put sawdust everywhere. They had tried to clear up the water to avoid accidents, and a worker had gotten injured all the same. And then the court weighed what could have been done to avoid the accident, and they said that the only thing that could have been done was if they shut down the factory. And you said that in shutting down the factory, the cost of the avoidance would be more than the cost of the accident, so the company was not held in breach. Thank you.
Thank you very much. Also, a very fantastic summary of that video on breach of duty of care. And I believe that if we all make efforts to watch these videos, it will be on the same pedestal, so to say. So thank you very much. She has given us an overview rather, of that video. And essentially, breach of duty of care imports the idea that even if you have established that somebody holds a duty of care, you don't stop at that. You must establish that they have breached the duty of care. So the fact that somebody drove on the road and hit another person does not actually mean they are liable. You have to establish first that they also breach the standard of care. Once there is a duty, there's always a standard in law, a measuring standard that you must use to say, okay, let us look at what you have done. Because tort is about interaction. And so we cannot say just once it happens, then you just make the person liable. Once the activity that you're engaged in, even when there is so much public outcry, like the example of those stampedes that we have talked about, the law cannot just pick them and say, okay, you organize this event, this stampede has happened, and people have died, then we prosecute you, or we jail you, or we say go and pay damages. They still have to interrogate that, okay, do you have a duty? If you gather people together, you have a duty. That's why when you have to go to social events, they will tell you, okay, these are the conveniences, these are the means of entry and exit in case of emergency. You can use these doors or that. You provide medical facilities to do that. So you look at what is your duty? What are you expected to do? These duties may be fixed by common law. They may be statutory duties. Because I told you that tort is also infused with so many statutes. You have health, safety, and environment laws, for instance. You have Factories Act. So you look at the standard that the law has said you should meet. Did you meet the standard of care? So the duty of care must have been breached. If you do not breach the duty of care, then you cannot hold the person liable. We talked about 3 elements: the duty of care, the breach of duty, and the resulting damage, which we say is actionable, is not actionable per se. Negligence is not, as a tort, is not actionable per se. So she has given us a very beautiful, and what you do, overview of that subtopic. What you do is to understand the fact that this breach of duty of care is the second element which you must establish. For you to establish it, you must understand the fact that there is a standard of care. The standard of care is an objective standard. It's an objective standard. The standard is not I have done my best. You don't talk about your best. Your miserable best would not be condoned by law if it does not meet the standard of the average ordinary person. Of course, the law can lay some standards for some category of people. For instance, children. A child's standard of care is not the same as that of an adult. But generally, when you talk about the ordinary average human being, adult, male and female, there is the objective test. So in that video, there is the component that talks about the standard of care, what it means. That is an objective standard. And you must have foresight. As a person, you are 20 years old. What do you understand about life? The average 20-year-old should have some understandings about basic things of life. You should know that if you want to cross the road, you should look at the road. If you know that if you are carrying fuel, the fuel is combustible. If you know that basic things, you must have foresight. And in that video, you notice I talked about that sometimes we expect that in looking at the objective standard, it's an objective standard. It's not my best that I've done my best, so I don't know what to do again. I don't care. Oh, she has no. That is not the business of the lawyer. It is your best. The law is going to look at you and say, this judge will sit down like somebody in that armchair and just look and into the world and say, what would an average person have done? It is not what the society, it may be that the most people in society do the wrong thing. I emphasize it in the video. The law is not going to say that, oh, the average Nigerian, like I said, for instance, they will run the traffic light. So the standard is that people run the traffic light in Nigeria and they will take one way, or that they will take one way. And therefore, since most Nigerian commercial drivers will take one way and run traffic light, if you have a case that involves a driver of a vehicle, then you say the standard in Nigeria is that people always run the traffic light. So when he ran the traffic light, he has not fallen. No, that's not it. What is the person that has normal intelligence? Normal person. So it's a fictional person. So you talk about the reasonable man aspect of that video. The reasonable man is a fictional person, it's a notional person. It's not that you bring somebody to court as a plaintiff or defendant and say, look, oh, this is what is the standard of care in this is what we normally do in the society. And that person will now come and testify and say, yes, that's what we do in society. So the person has done their best. No, he's a notional person, he's a fictional person created by the judges in England and so that aspect in England, in UK, in Nigeria, everywhere, in the US and Nigeria and any other jurisdiction. That is one aspect of that video. So if you now look at it, I said you must have that foresight of or the precision of an acrobat. If an acrobat, you can't afford to make a mistake. If they walk the rope, they walk it perfectly. So it's almost like saying you must know how to walk without making mistakes. Because negligence is a moral fault. Even if you say, I've done my best, the law will not listen to you. And then you move from that aspect of the objective test and then move on to the standards that the courts have used to determine some of the cases. In your case law, you see that they've talked about that. Yeah, some of the things they will use to evaluate your conduct. And those are the elements that he has brought out also. What is the magnitude of the risk? How risky is the venture? The riskier the thing you are doing, the more precaution you will take and you should take. What is the magnitude of the injury that can occur? And a classic example is that case of Parry and Stephanie Bodo Council, where somebody that has one eye, you're supposed to give the person to protect that single eye. If he loses one eye, he becomes completely blind, unlike somebody that has two eyes. The greater the risk, the greater the precautions. The greater the likelihood of injury, the higher the precautions, and so many other things. What is the object? What were you trying to do at the point? The objective, the intention, what is the motive? And you see some of the examples in the video. So what you are trying to do in this situation is to say, beyond the duty of care, have you met the standard of care? You will see that some of the other areas of law, there are different standards. If it's medical practice, for instance, to determine the standard of care, there are special rules that have been designed. We cannot look at all of them. So they will look at what is the practice in medicine, and we have to bring opinion of medical practitioners of like calling to come and testify that, okay, this is the way we treat typhoid, and this is the way we treat this one. In subsequent video, you see a situation where somebody is supposed to put whatever in a vein, in an artery, and put it in a vein, and the child became blind. Put what did they call it? I'll still get there to that one later. So the lesson from that video, it may be say threefold. You understand the importance of breach of duty of care as a second element of negligence. No matter how greatly I owe you a duty of care, if I have meant the standard of care, if I have not breached the duty of care, then there will be no negligence. How do we know that I have breached the duty of care? It's an objective test. What would a reasonable man do? If somebody is driving in University of Lagos road, what speed would they drive at? A reasonable man, not a mad person. Not saying this is what the average Nigerian does. I keep emphasizing that. Or this is the average youth does. What would a reasonable person do? Would you leave a knife hanging where you have a 3-year-old? You will use something that is poisonous hanging where you have children playing? Would you, you must have foresight. Sometimes I will tell my children, I say that pigs do that thing is going to fall, and Yorubas, they have a saying, they say what an adult can see sitting, a child will not see it even when they are standing. And therefore, if it's a child, God will look at the child of that age and say, what would be a reasonable child, a child of this age? What is the measure of learning and understanding that they should ordinarily have? and they will judge them by that standard. They will not judge a child the standard of an adult. But be that as it may, we should pick that point that it's an objective standard. It is not what you have done. What you have done. And like I used to say it in the physical classes, I don't know whether I said that in the video. If you do something and you have done your best, that in the court of heaven, God may allow it and say, because God has seen your heart, say, you have tried your best. But in the court that men have set up, they are going to judge you by what standard of other people, what the society tolerates. And that is just the general framework. There are special rules in some contexts that time will not permit us to look into. So we leave that one about breach of duty of care. So when you have your cases in the exam, it's not sufficient to say this person holds a person a duty of care. It's sufficient. We must go further to interrogate whether they have breached the duty of care. And those, after discussing the general framework of objective test, reasonable man, you see that reasonable man in criminal law, you see the reasonable man in tort. Reasonable man is going all over the place. Or the reasonable person in this age of gender or gender sensitivity, the reasonable person is not a man who masculine, is a person, and you are expected to have that standard of the reasonable person. Okay, so after you have mentioned that one, then you now talk about some of the elements to that the factors that courts have designed to say, okay, let's see whether you have done enough to meet the standard of care of a reasonable and prudent person. That is that. So let's go on to the next issue. When you have established the duty of care and you have established that this person has breached the duty of care by falling short of the standard of care of a reasonable and prudent man, which you find in Dologo and Stevenson in their classical formulation of neighborhood principle, doing what a reasonable man would do, or a reasonable person, if in language of today, what would a reasonable person do? Would you put food on the fire and go to lectures? Would you be on the road driving and be picking your calls? Will you put earplugs in your hair? Even if 100 million people are putting earplugs in their hair and they are walking on the road, is it a reasonable thing that any person that has normal intelligence should be doing? Because sometimes you see students or people on the road, and when you put earplugs, you cannot hear what is going on. If a vehicle is screeching and it's about to hit you, you cannot hear the noise. So if the person hits you, we can be talking about contributory negligence on your part. We'll talk about defenses later. So those are some of the things that we must begin to embrace as law students and as prospective lawyers. That you'll be measured by the standard of a reasonable and prudent person, not a person that is careless. So so we look at causation. In Tort, that's the next video. Did anybody look at the video on factual causation? The list I sent you has 14 videos, and that's 14 subtopics, 14 issues. Within those issues, there are sub-issues. So if you have not been watching them, you know where you are not going far at all. I also expect that you subscribe to that channel, and I'm watching at the subscription so that when I upload new ones, you get the notification as to what is going on, in terms of these further discussions. Okay, but I've uploaded 14 so far for you, and I expect that you subscribe and you get notifications about the subsequent ones. The factual causation, did anybody watch it and can give us a summary? The two people that have given us the summary of the first two videos, a fantastic job, and I've noted that. And I need somebody to also do something for us with regards to the to the next video. Factual causation, the but-for test. Any volunteer that you want to write your name in gold and you know that you have contributed to the class. I'm doing a list to anybody that I called. You cannot answer my question. I'm noting it. Those who can answer, those who volunteered and answered, I'm noting it. Those that I called and they answered by them and they answered the question, I'm noting it. Because some of you, I saw this guy now, he's been walking, I think he's in a broad street. He's been walking about since morning. He's left my screen now. You cannot be listening to lectures and be walking about. You're not doing us yourself, service. Even if you have videos, it's not, you still have to listen to the discussions. So I saw, what is his name again? I was going to note it down. He's been walking about since, as if he's going from Mowe to Broad Street. So any volunteer, or I should call you guys. The video on but for test, factual causation. Did anybody watch that? We are having lectures next week because we have to make up for the lectures that we didn't pick early. Nobody. Okay, I go to the next one. Factual causation, multiple causes. Did anybody watch that one? Damilare,
Hello, ma. Our hands are up, ma. So,
I just saw your hands now. Or is it?
Yes, ma.
Okay.
Factual causation, the but for test. You said in your video that the question of causation must be examined in most cases that deal with thoughts of negligence, and that causation is divided into two: causation in fact or factual causation, and causation in law, which is also legal causation. You also noted that the but for test gives the court direction in most cases, but it is not in all cases that the but for test can be used, especially in cases where there are multiple causation or causative agents. Then the but for test can't be used. Then causation deals with finding the connection between the breaching of duty by the defendant and the injury to the claimant. And it is also used to determine if it's actually the defendant's breach that led to the claimant's injury. Then in the case of Wallace and Kane, the two questions were formed for the court to use to answer, for the court to use to determine causation. The first one is a question of historical fact as to how particular harm occurred. And then the second one is a normative question as to whether legal responsibility for that particular harm occurring in that way should be attributed to a particular person. That means should the person be held liable for the particular harm that occurred in a particular way to the particular person. You said the general rule under the but for test. The but for test is the general test that has been developed for this type of inquiry. And it requires asking the question that would the claimant have suffered the harm he did, but for or without the defendant's fault? If the answer is that he would not have suffered the harm, then the defendant is not the factual cause. But if the answer is that the defendant or the claimant would have suffered the harm that he did due to the defendant's fault, then the defendant is actually the factual cause of the matter. Then the inquiry does not end there, though. The question of the legal causation would come in. Yes, that's it. And then also there's another question: that would the plaintiff's loss have occurred in any event without the defendant's breach? If the plaintiff's loss would have occurred, then the defendant cannot be held liable, and that would be the end of the inquiry. So if it was inevitable that loss would have occurred where the defendant's act is removed from the sequence of events, then the defendant is not the factual cause of the injury or the damage. Then you also talked about the application of the but for test and how it was applied in various cases, like case Cork against Kibbe and McLean, Barnett against Chelsea and Kensington Hospital, Williams against Sir Williams. There's one complex sounding case. I don't know how to pronounce it. Bangay, Bruxelles, something. Yes. Then you talked about the fact that the but for test uses the balance of probability approach. So the court treats probabilities as certainties in the but for test approach. That means if this was probable to happen, if an action was probable to happen based on like previous occurrence, then the court will definitely treat it as a certainty that this is what would have happened in case of this was named, in case in the case where negligence comes to play, which was seen especially in the case of Wiltshire and Essex Area Health Authority. Yeah, I think I would stop there for now, ma.
Thank you very much. Another beautiful summation of what this area is about: causation. causation is always a needed inquiry in law. Tort law, negligence, criminal law. Have you done causation in criminal law in any respect? Hello, can you hear me? Can you hear me?
Yes, ma'am.
Yes, ma'am.
Okay. Have you done causation in criminal law?
No, ma.
Okay. You will see that by the time you start dealing with homicide and other whatever, you would see this issue of causation also coming up. It's a needed inquiry in law because law. That's why sometimes I know when we were growing up, they used to say, lawyers are liars. Yes, you see black, call it white. You see white, you call it black. Yeah, maybe we saw this person shoot that person. And in tort, in criminal law, especially when issues of personal injury, it arises. Okay, so you can see that this person driving caused an accident and Mr. A is injured. And they took Mr. A to the hospital. And when they got to the hospital, other things happened. And then you ask, and then they say, okay, is he responsible? Causation. If I say I don't want to take blood transfusion, but they say they want to amputate the person's leg, said no, and the person dies. They say if you don't amputate the leg, the person will die. The person says he would rather die than get amputated. Or when you get to the hospital, the doctor gives the wrong treatment. Okay? Or so many other factors will come in. You begin to examine position. The law is not just it's not just what you see on the streets that will represent the state of the law. Oh, this person's act or omission has caused this kind of loss, whether death, whether personal injury, whether financial loss. A lawyer has given a legal opinion, then the company suffers some financial losses. You cannot just say, oh, because you are the one that give an opinion. The law will still scrutinize. What is the relationship between the act of the defendant and the injury that occurred? The relationship, the nexus, the connection, the chain, what ties them together? What ties them together? Sometimes you have heard stories. Somebody will just slap a man and the person just collapses and dies. Should the person be responsible? So in law, we are not interested only in the fact that you hold a duty of care. We are not interested only in the fact that there is a breach. You might have breached the duty standard of care. Then we say damage must have occurred. Now that damage that occurred, is it a result of the breach of your duty of care? Because the damage that occurred may not be the consequence, the natural flow from that breach of duty. So in causation, we are looking at some things. We are looking at on that video, you looked at the significance of factual causation, and we said that causation is twofold. There is the factual one, and there is the legal causation, which we call remoteness of damage, which is the next part of the videos. So we are in causation, you are trying to find the connection between the wrong of the defendant. Oh, he drove negligently and hit somebody, or he treated a patient and prescribed a drug. Financial advice as a financial advisor, and somebody suffered loss. All these things, what is the connection between the loss that the person eventually suffers? So the company invested in that business that you advise them to invest in, and they suffered a loss. Are you sure that it is your advice that caused the loss, or something else that caused the loss? The law must find that link. So two forms of causation you must know as a student of tort of negligence: the factual causation and the legal causation. Both must be established. The factual causation and the causation generally is trying to find out the two questions. What first, that historically, looking at the antecedent of the wrong, of the injury to the plaintiff, who caused it? Who caused it? That's the factual causation. This injury would have occurred, and that but for test is the standard test. but for the act of the defendant, would this injury have occurred? Is a factually, from what you can see by your senses, who caused it? Like we talked about the stampede in the various parts of the country, as a matter of factual causation, those children in Ibadan that are alleged to have died as a result of the stampede, would they have died but for the fact that they attended that program? Factual causation will say no, they would not have died. As a matter of historical evidence. Can you hear me?
Yes, ma'am.
Yes, ma'am.
Okay.
Yes, ma'am.
As a matter of historical evidence, they would not have died. That's the business of factual causation. So if something would not have happened but for your act is what has caused that thing. That's just factually. But you don't stop there in law. You will still go ahead and say, who, legally speaking, as a matter of legal responsibility, is that person the cause of the death? Is that person the cause of the loss, financial loss, the business loss, the economic loss, the property damage? You still have to determine that as a matter of legal causation, what we call remoteness of damage. Okay, so the second question would be whether legal responsibility for that particular harm should be ascribed to the defendant. So two forms of causation you learn from that video, the factual one and the legal causation. The but for test. Would it have happened if the defendant did not do what he did? No. And I gave you just a recent example. I'm not telling you that the stampede is Ibadan is the responsibility, is the fault of anybody. I'm just using it as an example to tell you that if that factual causation would say, as a starting point, this incident that happened in Ibadan or in the east or in the north, or the Hillsborough litigation that happened in London at that sporting event, would it have happened if they didn't organize this football event? It would not have happened. So factually, the organizers are the cause of these injuries and deaths, as a matter of fact. But legal responsibility must go beyond that and say, now let us look at it critically and say, what is the nexus between the injury and your legal wrong, your omission? Okay? So but for test, you must know it from that video and understand it. And I've tried to explain it in many ways, irrespective of if the incident would have happened, irrespective of the what you did, then you would not be like when we looked at Cork and Kirby, application of the but for test. Cork and Kirby and McLean's, go and look at those cases, and Lord Dennis' formulation of the but for test is also there on page 407. And then we looked at other cases, Barnett and Chelsea and Kensington management. That is a locus classicus case as well, where the person did not, went to the doctor for medical treatment with extreme stomach pain, and he did not, he was not treated, he was told to come back the following day. Apparently, he had been poisoned, and he was told to come back the following day, he was not treated. By that following day, 11 a.m., he was dead, or thereabout. He was dead. And the issue was, what killed him? Yes, it was not the doctor that poisoned him. It wasn't the hospital management that poisoned him. Okay? That was not the case. He was poisoned by somebody else and something that he had eaten. But he came to the hospital for treatment. He was not attended to. You see so many things like that happening in the country. And then he said, come back the following day. Before then, he was dead. And typical human reaction, say, it's the hospital that killed him. If they had treated him, he would not have died, this and that. When the case came so factually, the but for test was now called into question. Is it that the hospital was factually responsible for the death of this man? We are not even going to the legal responsibility now, the remoteness of damage. And the court inquired and found out that even if they had treated him, that if he had been attended to, the kind of poison that he was suffering from was such that they could not have gotten an antidote for hours, almost over 24 hours, even after the treatment then. So even if they had treated him, they would not have been able to get the antidote, which was a very rare one, and he would still have died in any case. So if he had been treated, would he have died? yes, he would have died. Therefore, the breach of duty by the hospital management was not the factual cause of death. Was not to be factual cause of death. And so, factually, the hospital was not responsible. That is the first stage of the inquiry in the negligence process. If factually the hospital was not responsible, let us assume that the hospital was responsible. They will not stop there. They will now look at legal responsibility as well in under remoteness of damage. So the hospital was not held liable. Then you have Williams and Sir Williams and co steel rector, where a worker died because steel rector was not and safety harness was not safety harness was not provided for someone that was a steel erector, and he was climbing, during the construction, and he fell. And the question was, but whether factually the employers were responsible. And there was evidence that in the past, even if they had provided it, he would not have used it. And what is a probability in negligence is usually treated as a certainty. If historically he had not been using it, if they had not been using your safety goggle, your safety harness, everything that they use as an equipment at a place of work, then there is that high probability that the day the person had that injury or died, they still may not have used it. So the breach of duty was not the cause of death. So please, you need to read those cases. I want you to also read that case, the Lord Hoffman's mountaineering example, where he gave a very classic example of how to look at but-for test. And at the next class, I'm going to ask you about that mountaineering example in the Samco case to see whether you are following the discussion. I'm not going to. So the but-for test is the classic test for causation, for the factual causation. And if you are able to show that this person would not have suffered the harm they suffered, but for the act or omission of the defendant, then the defendant is factually responsible for the loss. Then you now go ahead to the question of legal position, that is remoteness of damage. Now, this is how negligence works. You have determined that there's a duty of care. You have determined that there's a breach of duty. You have determined that factually this person is responsible. If you declare that factually this person is not responsible, that's the end of the case. You don't have to go to legal causation. You don't have to go to legal causation. But sometimes, but-for test does not help you. Where you have more than one cause, if you apply the but-for test, it will not help. Nobody will actually be held responsible. I would expect, because most of you have not watched this video, so tell me how that but-for test suffers a limitation. That's when you begin to talk about multiple causes, indeterminate causes, where two or more things caused a particular injury. If you apply the but-for test, you may find out that nobody is liable. If my car was hit by Mr. A and Mr. B, maybe a multiple collision case. If you apply the but-for test, both of them hit the car from the back and the headlights are broken. If you apply the but-for test, Mr. A will not be liable, Mr. B will not be liable. Because you say, if would injury have occurred, the headlights, will I have lost my headlights if Mr. A did not hit me? Yes, I would have lost my headlights because Mr. B would still have hit me. So Mr. A is not responsible. But you are going to apply the but-for test towards Mr. B too. And at the end of the day, nobody is responsible. So these things require some logic. You have to sit back, read the cases, know that the general rule is the but-for test. Know that there are some cases where the but-for test will not apply and special rules have been determined, like we are going to look at in other subsequent videos. And then understand that, in summary, the loss of causation are necessary components of the negligence inquiry, and that injury, there must be a relationship. Okay, if somebody cannot find that relationship, there's no need to say the person is responsible. That is what outsiders, people that have not legally trained, would see and say, these people are liars. You don't know why now. We saw this man, slap this woman. How can you say it's not responsible? Factually, they can see the slap. But the lawyer can come to court and say, yes, this woman was slapped, but this continuous migraine that she started suffering from that time was not a result of the slap, because medically it has been demonstrated that this migraine has nothing to do with the slap. But you can just say, this is the day that she was slapped that she started suffering from migraine. So the outsider would think, oh, lawyer, they've taken a lawyer, they will now twist the case and change the case in our presence. But that's not what is happening. It's a question of causation that may not be established. Somebody somebody has an accident and say, at the end of the day, 3 weeks later, say he's dead. So the whole world, the man that caused the accident is the one that killed him. The one that ran his vehicle into the other person. But the law may say, looking at the way the person has driven the car, the precautions taken, the speed and everything, this person has not breached the standard of care. He has driven as a reasonable and prudent man. What happened was an act of God. I'm sure you're beginning to get used to those defenses. Oh, it was because there was an act of God, a natural event that took over the driving, whatever. Or it was just a case of pure accident. That if a reasonable and prudent man had driven that car in that same condition, they would have driven the way he has driven, and they would have had this accident that occurred. That is what we call accident in law. What you as laymen would call accident is not what the lawyer would call an accident. An accident would be that you have taken all the natural precautions that a reasonable and prudent man would take, and this incident will still be unavoidable. They will say it's a case of accident. These cases are very rare. Accident cases, what we can call legal accidents, they are very rare. Because for you to constitute something as an accident, you must be sure your cars are in good condition, you service it, your brakes are not failing, your these are not, so many things. So you have to begin to expand your horizon, your mindset, and begin to understand what law does and how lawyers reason. And don't feel condemned and say, oh, you are liars, they are just come to scatter the case. Can you imagine that case? After we have seen that it was one that injured that child and the child has died, they say it's not responsible, it's not liable. Meanwhile, the courts have examined it based on medical evidence and every other kind of evidence and seen that the incident of being hit by that car had nothing to do with the death of the child, even though the child had died subsequent to the accident. Okay, so that's just about the causation in fact. It is in using this test that court decide on the balance of probabilities what is more likely than not to happen has happened. Injuries that are multiple or not indeterminate, you cannot use the but-for test. You will not find an answer. Special rules have been designed, and the court would use these special rules. You have something we call all or nothing approach, and that would say you are responsible for everything or you are not responsible at all. Please look at this aspect of the course critically. The but-for test and causation in fact, this one that we have looked at, causation in fact, multiple causes, causation indeterminate causes, and remoteness of damage. You need to listen to the videos over and over and over again to understand what we are talking about. But when you understand it, it's a very beautiful exposition because it gives you clearer direction as to why some cases we say you are liable and some will say you are not liable. If I give you a legal financial advice or legal advice as a lawyer, and you now suffer a loss and you sue me, the court is not just going to say because I gave you an advice, then that's why you have suffered the loss. You are saying, what is the advice? We did legend misstatement last week, on Monday. What was the advice given? Who was he given to? What was the purpose for which you wanted the advice? What purpose did you use the advice for? The loss that occurred, is it flowing from the advice or just something that is secondary to the advice? These questions are asked in detail in litigation before you can say somebody is liable. Okay. So with that aspect, we'll stop today, and next week we are going to be looking at about 3 or more other videos in the next class to see the framework. At the end of this, I'm going to, like I said for the other class, I'm going to still have discussions where we look at past questions. But up till now, I've not seen that diligence in watching the videos and helping us to have robust discussions. Please go and watch those videos. I'm going to take the next, that way I'm giving you the list. watch the next 4 sets of videos before Monday and let us be on the same page. When we finish all these video discussions and this, we are going to start taking tutorial questions. Okay, questions on the first semester topics. So get your past questions ready, and I'll see you at the next class. Have a nice day.
And you too, ma.
Thank you, ma.
Okay.
Thank
Welcome.
you,
Thank you,
Thank
ma'am.
you, ma.